I think. Okay. Hello and welcome, everyone. My name is Johanna Lorenzo. I'm assistant professor at the Amsterdam Center for International Law. And we at ACIL are very pleased to open the new year with this lecture on emotions and international law by Anne Saab, who is joining us today from the Graduate Institute in Geneva, where she is currently associate professor and is also serving as the co-director of the LLM in International Law program. Her areas of interest and expertise include food and agriculture, climate change, intellectual property law, and as we will hear about more today, emotions and international law. So I'm sure we're all raring to hear about this fascinating topic, but just before I completely turn over the screen and the mic to Anne, let me just remind everyone of how the format of today's lecture. So as we've been doing in the past for 35 minutes, Anne will be presenting her paper, which was also circulated to everyone who registered for this event. And afterwards, we will open the floor for a Q&A from the audience. And so without further ado, Anne, please.
Thank you so much, Johanna. Thank you for the invitation, and thank you also to Kiki, who's here for I guess, suggesting my name for this seminar. Really delighted to be here with you, even though it's virtually. I was just saying to Johanna and Alicia before that I was actually in the Netherlands until about 10 days ago for Christmas, but I'm back in Geneva. So there we go. I think it probably wouldn't have made much of a difference because we might have just been doing this online. Anyway, so thank you so much for this invitation. I will so I'm going to be speaking about quite a big new research project that I am working on, which is very broadly on emotions and international law, which I know is an enormous topic and an enormous area. The paper or the piece that I shared with you is a piece that I published a couple of months ago in the ESIL Reflections series. So as you probably all know, it's a short piece that was really intended to just put the topic out there and say, hey, this is something that I think is really worth looking into in a lot more detail as an international lawyer, as in the field of international law. So what are we doing with emotions? What I will start off doing is just give a little bit of background into how I came to this topic, why it interested me, what's the story behind it. I always find it interesting to hear what people's motivations are in terms of what they're researching, and perhaps especially with a topic that isn't as straightforward. So when I was doing my doctoral research in London, broadly my topic was about climate change and hunger, and I was looking at seeds that were genetically modified to be climate resistant. So seeds that were genetically modified to be resistant to droughts, for instance. And my interest in my doctoral research was looking at the ways in which international law is really used as a discourse to say something about that presumed adaptation strategy to climate change. So is this a good adaptation strategy to climate change? What do we think about genetically modified seeds? What is the problem of climate change and hunger? So that was broadly my what I was looking at in my doctoral research. And I became really fascinated, just kind of as an on the side while I was doing my research, in the very emotional language that was used when discussing climate change and hunger, and especially language of fear. So very much a fearful kind of language. And in my perception, I felt that was becoming more. So really an increasing as we started to, well, now really realize that climate change really is a very serious problem. It's something that's urgent. We need to deal with it, but also the way that it's communicated about is increasingly fearful. This might have just been my perception because I happen to be spending my days researching about this topic, but I became very interested in it. It obviously wasn't something that I was able to look into in any detail while I was doing my doctoral research, but I sort of parked it and I just kept this fascination for it. So thinking about how does international law engage with this kind of emotional language around the topic of climate change, and especially how does it engage? What's the effect of this sort of fearful communication about climate change and these representations that very much had to do with emotions, of course. So I didn't do anything actively with that topic for quite a few years after I had sort of put it somewhere in the in a folder that I called research for later, that's filled with all sorts of things that I at some point in my life, maybe or maybe not, I will get to. But this was really my priority after sort of harvesting, let's say, all the bits that I wanted to do from my PhD project. So after I'd completed my book that came out of my PhD, I thought, okay, this is something I really want to look into in more detail. For me, this was something that was very new. As an international lawyer, we don't learn to study emotions. That's not something that we study at all. At least that's not something that I ever studied in any active way in my law degrees. And then, of course, as tends to happen with a new topic that you think is so new to you, there's a whole world out there of studies on emotions, studies of discourses of fear around climate change, for instance, and what the effects of that were. So I became really interested in thinking about, okay, what does that mean for international law? How do we engage with emotions? And that's really where this piece came from. So I tried to backtrack a little bit and think, okay, how do we bring the study of emotions into international law, and what are some other examples as well? So of course, I was studying climate change and food and agriculture and looking at those questions in particular. But what are some other examples of where we could be looking at the relevance of emotions, and then also thinking about why should we care as international lawyers? Why should we care about the effects of emotions, and why should we care about the effects that we as international lawyers in many different ways have on emotions as well? So that's really the background to it. What I'm aiming to do with this project, so I am currently writing or revising an article that I've been working on and off for a few years, which is precisely what I started my interest with on discourses of fear and international law on climate change. And I focus specifically on human rights law that engages with climate change. So I look at how is fearful rhetoric used in human rights law on climate change. So that's one piece that I'm writing, but that's a very particularly focused topic. What I also am working on is a bigger book project which really tries to elaborate on some of the things that I've put forth here in this reflections piece, which is what can we do as international lawyers in engaging with emotions? Why does it matter? And what have other disciplines been doing in looking at emotions? So the starting point really is that there's an enormously rich history in the study of emotions in other disciplines, but in legal scholarship, including in international law, it does remain marginal and somewhat neglected. And to be very fair, since I've been working on this topic, every presentation that I've given or every engagement that I've had on the topic, I can probably use one hand, and not even all the fingers on one hand, to count the number of people who have come up outright and said, well, emotions are not relevant for international law. by far, most people don't question this. So I don't get any pushback. Well, of course, emotions are not relevant. Yes, emotions are relevant. But the biggest pushback that I get is, well, what do we do with emotions and how should we be engaging with emotions? So my starting point is that we should be engaging with emotions. My starting point is that international law is a social construction. Also, there's not a whole lot of pushback against that statement. But the biggest pushback is that I've received, at least, is, first of all, how do you measure emotions? What are emotions? Are you going to do empirical research to prove in what way emotions work? And then I guess an overarching fear or concern that I've heard from fellow lawyers in presenting this work is that there's this idea that if you engage with emotions, you're therefore undermining reason and undermining rationality. And this is really a big, seemingly a big concern. Law is still very much based on reason. And there's this idea that reason and emotion are two separate things and they're separable, and that law should be grounded on the side of reason. And this is something that I really want to deconstruct a little bit, or not a little bit, a lot in this research, and really by using research that's been done in other disciplines already. So my idea in this introductory piece is not to say this is how a particular emotion affects international law, or this is how international law affects a particular emotion. So really not to make any big normative statements at this point, but just to say, hey, look, emotions do influence everything that we do across all areas of international law. We as international lawyers, in whatever work we're doing, are also influencing emotions in some way or the other, and we need to engage with that question. So that's really all I want to put out there in this piece. And I wanted to start off with some examples that I mentioned, and these are not exhaustive at all, of course, but I put some examples in this piece because I just wanted to show, okay, where could we be looking for if we're looking for the relevance of emotions in international law. So the first example that I mentioned here was fear and anxiety in food safety law. So that's something that I've been looking at. So it makes sense, of course, in addition to the research that I've been doing on climate change, looking at food and food questions of food safety. So one of the things that I've been looking into is what kind of food safety regulations exist, for example, around genetically modified foods. I've written some things about the different types of regulation on genetically modified foods. I've been teaching a course on global food systems, which is for an interdisciplinary audience of students, but it very much focuses on the legal perspective. And one thing that's very interesting, that always struck me as something that was very interesting, is that a lot of the big controversies around genetically modified food are very much emotional. They're very much emotional controversies around, well, people don't trust this food. They don't like the sort of unnaturalness about genetic modification. There's also often this quite stereotypical, which is it's a stereotype because, of course, it's based on truth to an extent as well, between this very different approach between like a European approach to regulating food safety questions, especially when it comes to genetically modified food, and the more North American US approach, where the US approach is much more permissive and the European approach is much more precautionary. So much more, okay, we're not going to accept this so easily unless there's proof that genetically modified food is safe. Whereas in the US, it's more, well, hey, prove to us that it isn't safe. What I found especially interesting in looking into these questions is that very often there's not really a big difference. There are no big differences in terms of scientific information and scientific evidence. For example, in disputes before the WTO, there are not big differences in scientific evidence that are brought. So the difference is often not, well, this party thinks it's absolutely safe and this party thinks it's absolutely unsafe. And here are enormously different facts that are brought. So a lot of the hesitations come from something other than scientific facts and evidence. And this is something that's known. I mean, it's acknowledged even in one of the disputes before the WTO. There was an argument that was being made that public perception of what is dangerous should be considered in addition to scientific factors in judging whether a measure constitutes discrimination. So in this case, it was about a genetically modified food that was being blocked in Europe, and the US had brought a case about that, saying, well, hey, this is discriminatory. Where even before the WTO, the panel said public perception of what is dangerous should also be considered in addition to scientific evidence. So what I really want to show here is that not to say this is how cases should be judged when we look at food safety questions or when we look at genetic modification, but to say that this is relevant for international lawyers, in this case, for international trade lawyers, for WTO lawyers who are looking into these cases on trade questions about genetically modified food. It's not only about the scientific evidence. It's not only about the facts and evidence of what is safe and what isn't safe, but it's also about emotional considerations. How do consumers feel towards certain foods? Why do they feel that way? Is there something that you can do to change, for instance, perceptions that are not based just on throwing more science at people, throwing more facts at people? And this is something, of course, that's not new at all in disciplines that are outside of the law. I mean, there's a lot of, there's a whole history of work being done that is on how do you communicate, really? What's the psychology behind this? And I think that that's something that that lawyers need to engage with. And that's not to say that I'm going to give you my view on, for instance, whether genetically modified food should be acceptable or not in a particular case, but that it should be acknowledged that emotions, and in this case, fear and anxiety towards GM food, should be taken into account seriously. A second example that I included, which, to be honest, I was a little bit hesitant about including this example because things change so quickly, is about COVID. And specifically the emotions of shame and stigma. There's a lot of work that has been done on shame and stigma in combating infectious diseases, particularly AIDS and other sexually transmitted diseases, that I think are very relevant as well when we look at measures that are taken to deal with the current pandemic that's ongoing. And I looked at shame and stigma because I think things like some things that just struck me and that still strike me. I hear quite a few people these days saying, oh, so-and-so got infected from so-and-so, or this person infected their whole families. And I have to say, even when I traveled home over Christmas, I thought, oh gosh, I really hope that if somebody gets infected in my family or in my, that it won't come across that it was me or that it was my children who infected them. And it's this kind of, you feel like there's some sort of load to that. And of course, there's a good reason to make people aware of, okay, you don't want to be the one infecting other people. There are things that you have to do to try to avoid spreading this disease. But there's been a lot of research done, for instance, on shame and on stigma related to HIV/AIDS. And it's not all positive what the outcome of that is. It can lead to people not wanting to disclose, not wanting to disclose the fact that they've been tested positive, for instance. And so I think that that's something important to consider as well when you're making laws, is how does that affect people's emotional states, and what does that mean for how people will behave as well. So, and I think that's important not only for psychologists who might be studying this, or people who are looking at this from a global health perspective, but also as international lawyers. And maybe I should have said this at the outset of my presentation. My assumption here is that international law is actually trying to address, or trying to contribute its part to addressing these global issues. So not just, hey, let's make laws that technically work well, or that technically are in order. But I think when you're looking at, for instance, whether it's food safety or whether it's global health, the intention is that you're contributing positively to this as international lawyers. So that was another area that I think is interesting and is necessary to engage with the emotional dimensions as well of health risks and what that means for international law in dealing with those issues. Then a third area that I looked at here was artificial intelligence in warfare, and especially lethal autonomous weapon systems, or sometimes called killer robots. So I think that's something that's incredibly interesting, especially and I mean, of course, there's a lot of discussion, a lot of work going on in this area, particularly humanitarian lawyers who were looking at these questions, including one of my colleagues here, Paula Gaeta, who's working on a project on precisely this, lethal autonomous weapon systems. And this topic is enormously loaded with emotions, regardless of what side you take in this debate. So there are proponents of lethal autonomous weapon systems who would say that it is useful to remove human emotions, such as anger and vengeance and fear, to remove these emotions from situations of war. On the other hand, there are opponents who would say there are other types of emotions, for instance, empathy, compassion, and dignity. Killer robots don't have those positive emotions, so they can't have empathy. They can't have compassion with another person. So therefore, precisely these types of autonomous weapon systems are not fit for warfare. So regardless of what position you take in that debate, we have to acknowledge that there are emotional considerations here as well. I looked at this concept in international humanitarian law of reasonable commanders. So reasonable commanders in assessing the proportionality principle. And what I found really interesting, at least in how I read, what reasonable commanders are, this idea of reasonable, I think reasonable commanders seem to be not reasonable because they lack emotions, but precisely because they have emotions, because they're human commands. So the reason comes with the emotions, not some separation of here's some mechanical decision that's being made, but really very much an emotional decision as well in warfare. So again, whatever perspective you take in this debate, or maybe on the fence, really on this question on whether you're for or against lethal autonomous weapon systems, the reality is that it's very much emotionally loaded, and we have to deal with this question of how do emotions play into human decision making, and how does that affect our discussions on lethal autonomous weapon systems in international humanitarian law. So just 3 examples of how emotions work how emotions work in international law, and something that I think I should emphasize here as well. And that's something that I've gotten quite some questions on in previous presentations as well, which is what I want to look at is not only the effect of emotions on international law, but also how international law itself affects emotions. So I could use the example of global health laws. How do particular laws maybe promote shame and stigma? And what impact does that have? How do certain laws maybe foster hope on a certain topic? So for instance, when we look at climate change, there's been quite a bit of work done recently that really says this sort of excessively fearful representation of climate change isn't very productive in getting people to engage and getting people to act on climate change. So perhaps it would be more useful to have a more hopeful message. And I think that international law plays a role in that as well. So for instance, when I was looking at what I sort of call discourses of fear in international human rights law, there's very much an emphasis on presenting climate change as a big threat, which is, I'm not denying that it is a big threat, but in terms of what effects that kinds of communication has, sort of wonder, okay, would it make a difference if that kind of communication, that sort of discourse is adjusted and there's a more hopeful message presented there? So really, I'm trying to look at the relationship both ways. So how do emotions influence international law, and how does international law influence emotions in many different ways? So why is it important? And I think that's something that I should say a few words about. Why is it important? And it's a valid question. Why does it matter? Or why is it important to look at emotions in international law and to really actively engage with emotions? I think because we are talking about real issues as international lawyers. So these aren't something on paper that we're engaging with. These are real questions that have real effects. So when we look at lethal autonomous weapons systems, the choices that are made and how international humanitarian law is adjusted in response to that makes a real difference, of course, to people. What kind of warfare are you waging? It's not just a reasonable, let's say, here are the facts. Here are the facts about a situation, and this is the decision that's being made, but it's very emotionally loaded. So I think that also, I guess, in a more selfish, perhaps, way as an international lawyer, I think the field of international law is really at risk of putting itself outside of the important questions and really not engaging with these global issues if we don't also actively engage with the emotional sphere as well. So I wanted to go back to something that I introduced earlier, which is, why is it that I think, or why is it that I've come to believe that that international law does not engage with emotions in an active way at all? It really comes down to where it starts with this, what I think is a false dichotomy between reason and emotion. So a lot of the pushback that I've gotten, and not just me, but people who've worked much more on law and emotions, the pushback is really this idea that if you engage with emotions are messy, they're subjective, they're difficult to pin down. You don't know exactly what you're talking about. I've gotten quite a lot of comments saying, well, you say that it's fear, but people aren't actually afraid. Well, I mean, I'm talking about discourses of fear, which doesn't mean that people are actually, that individuals are actually afraid, but it's still an emotion. So this idea that if you somehow embrace or engage with emotions, that you have no idea what you're doing anymore, that there's no, you don't have any kind of objective way to analyze, right? So this idea that if you're going to engage with emotions, that all reason will be lost. So it's either reason or emotion, and really this sort of dichotomy between the two. And I'm not, of course, I'm not the only one who has said this. There are plenty of colleagues who write about, the dominance or this presumption of reason, of rationality in law. Among them, Pierre Schlag, who's written brilliantly on, well, this was a book about the American legal tradition, The Enchantment of Reason. So really all this idea that with law, we're seeking the truth or the one correct answer, and we're basing ourselves on indisputable facts and evidence. There has been a lot of pushback against this from various strands of international law. So I think it's important to mention that, so as not to come across as if I'm ignoring all those areas of law. So feminist scholars, critical legal scholars, really challenging this mainstream rationalist approach to law and accepting much more the constructed nature of law and its various influences, but still actually focusing on emotions as such has been very limited. There has been some work done. There has been quite a bit of work done actually in the past 20 or so years in the field of law and emotions, which has focused almost entirely within the US. So it's really been very much a US. And what's also, I mean, this is something that's just, it's too obvious to not notice. It's almost all women. I mean, honestly, I don't think it would be hard to find a man who's working on law and emotions. And this, I guess, reinforces in this gender perspective that it's somehow that it's, of course, it's women who are studying emotions because they're sort of the emotional creatures. But law and emotions has really been an emerging field, and it's gone outside of the US as well. There, in the UK, there's more scholarship on law and emotions. There was a recent book that was published, the Research Handbook on Emotion and Law, and in the introduction, the editors of this volume say, and I'm quoting this, "Understanding emotion is an essential part of building a fairer, more effective system." And I really believe that very strongly. And I think that should be something that we look at much more closely in international law. So rather than seeing reason and emotion as dichotomous, what I'd like to put forward here, and again, this is not an argument that I am making myself out of the blue, but I simply want to reinforce this in the field of international law, is that it's emotion and reason, not emotion or reason. So what I'm certainly not trying to say is that we should just let emotions in all parts of our legal decision making and legal analysis, and therefore disregard all scientific facts and evidence. And you come to this sort of, I don't even want to say the word, but I'm going to say it anyway, the sort of post-truth idea that, you know, whatever truth is yours and that works. I mean, this is very problematic, but I think it's also very problematic to suggest that if you acknowledge that there are emotions and that these emotions do have an impact, that necessarily undermines the rule of law that you would have, or that denies science, denies facts and evidence. It doesn't, but they're both part of decision making. So reason and emotion is both part of this package, and this is a point where law and emotion scholars really differ from, for instance, behavioral law and economics. So when you look at behavioral law and economics, there's a recognition of, among other things, emotions, But there's this idea that emotions are cognitive biases, and that they should be kept out of lawmaking. And this is what you can see, for instance, in Cass Sunstein's work as well. So he's written about fear and environmental law broadly. So he recognizes in his work the relevance of fear for law, but he views fear as a cognitive bias that leads to a deviation from rational behavior. So there's still very much this idea that reason and emotion are two separate things. And so in as far as emotion is acknowledged in law, it should be somehow kept out of the law. So yes, the emotion are there, but it shouldn't play a role in how we make our decisions. In law and emotion scholarship is really different because it says emotions are there. And we have to engage with them. We can't block them out. So you have to deal with that somehow. And that's something that I really think it's high time for international lawyers also to be engaging with. So there we go. That's really what I wanted to present as an introduction. And I hope that was somewhat clear. I know it's a very big area, and I'm very much looking forward to, I guess, spending my time on this for some years to come. And I'll look forward to hearing your questions and your comments.